Welcome to Radio Law. This is Dr. John Olson. In this piece, I'm going to discuss the recent statement by John Bolton, the U.S. National Security Advisor on the International Criminal Court, abbreviated ICC. In his statement, Mr. Bolton said that the U.S. will not cooperate with or provide assistance to or join the ICC, and he further said, "We will let the ICC die on its own." Now, Mr. Bolton's statement appears to be motivated by two things. First, the ICC's request for a full investigation into alleged war crimes in Afghanistan, including any alleged to have been committed by U.S. military personnel. Two, the ICC's moves to bring Israel before the ICC on the basis of alleged human rights against Palestinians. First, a few words about the ICC. The ICC was set up following a number of recent conflicts across the globe. It began its existence officially after the Rome Statute came into effect in 2002. The idea of this international treaty was to bring to justice officials who had committed war crimes, genocide, and crimes against humanity in cases where an individual state was unwilling or unable to prosecute those offences itself. You should know that in any international treaty, any state may become a signatory to that treaty, but it is not a full participant in that treaty until it ratifies it. So there are two steps a state needs to take. First, it signs the treaty, which signals an intention, and then later ratifies the treaty, in which case it becomes bound by the conditions of the treaty. The United States signed the Rome Statute in the year 2000, but it has never ratified it, which means it is not bound by it. More than that, the United States has signaled its intention to withdraw its signature from the treaty, or at least never to ratify it. So it is important to realize the United States is not a state party to the Rome Statute. It has not agreed to be bound by the ICC, which means that if the ICC issues a warrant for the arrest of any United States citizen or any person within United States territory, the US does not have to take any steps to arrest that person or to extradite him or her to the ICC. So, because the US is not a state party to the ICC, it is not bound by it. The ICC has no jurisdiction over citizens or residents of the US. Now, there are several other factors. The Rome Statute recognizes that where a state is willing or able to investigate war crimes, crimes against humanity, and genocide, then the court will respect that and let the individual state concerned deal with the matter itself. This is known as the principle of complementarity. So the ICC only gets involved if a state is unable or unwilling to investigate. Now, it is the US position that it respects the rule of law and the rules of war, and in its favor, it must be said, the US military and other authorities have launched many investigations, including an incident in Iraq where more than 20 men, women, and children were killed by US Marines. And of course, everyone will remember the horrors of Abu Ghraib prison in Iraq and the conviction of 11 US soldiers, including Staff Sergeant Calvin Gibbs, of the murder of 3 civilians in 2011 in Afghanistan. So as a result, the US considers that it does take action against violations of the Geneva Convention and its own rules of war, and therefore in its view there is no need for involvement by the ICC. The US view appears to be that the ICC is not respecting the fact that the US investigates any allegations of violations of the rules of war. It should also be said, in fairness to ICC procedures, that at this time the ICC prosecutor has not yet obtained warrants against any US personnel. The ICC prosecutor has to go through a procedure to get permission from the court to do so, and the ICC prosecutor cannot act on his or her own. The court would have to be sure of two things. First, that there is a prima facie case against US personnel, and second, that the US was not able or willing to investigate and, if necessary, prosecute its own personnel. This would be no easy burden for the prosecutor to prove to the court. Of course, I do not know what evidence the ICC prosecutor has or doesn't have, but I suggest that the application to the court might be defeated on the second ground. The court may take the view that since the US appears to have shown itself willing and able to investigate and prosecute its own military personnel, then the ICC would have to recognize the doctrine of complementarity and leave the US to get on with it. Also, as I mentioned earlier, the ICC has no jurisdiction over US citizens or US residents within US borders, and a prosecution would only take place if a member of the US military who was subject of an ICC warrant was arrested whilst travelling internationally. There is another point, of course, which is the constitutional one. The US Constitution is the supreme law of the United States, other than where the United States has signed extradition treaties, which it has with about 100 different countries. It will not surrender its citizens or residents. There is no authorization in the Constitution for rendition of a US citizen to any other state or authority. This places the US in something of a difficulty in relation to the ICC. No executive authority in the US is empowered to allow a US citizen to face charges at the ICC, and for this reason, any attempt at a prosecution by the ICC is likely to fail. All the ICC can do is to bring international focus to actions of international law violations which it alleges that the US military personnel have committed. Equally, the US relies on its own American Service Members Protection Act of 2002, which not only prevents the extradition of US military personnel to any other authority, it actually mandates the President to take all necessary steps to obtain the release of military personnel held by non-US authorities. So, leaving aside questions of political motivation on either side of the debate, it's clear that as long as the US continues to abide by international law and the law of war and vigorously carries out its own investigations and, where appropriate, prosecutions, there is little the ICC can or should do. However, the US should not speak disrespectfully of the ICC, as National Security Advisor John Bolton has done by declaring that the ICC is dead to the US or by threatening sanctions. The ICC is mandated by over 100 countries as the tribunal for war, humanity and genocidal crimes, and if it receives credible information regarding allegations against any military personnel in any state's territory or where crimes are alleged to have been committed in one or other theatre of war, then the ICC is bound to investigate, and the US should respect this, even if it does not agree with it. By Article 5 of the Rome Statute, the ICC is obliged, not just mandated, but obliged to exercise its jurisdiction. So although the US is not a party to the Rome Statute of the ICC, the allegations against military personnel concern events that happened in a member state of the ICC, namely Afghanistan. For these reasons, the ICC prosecutor has no option but to conduct at least preliminary investigations, and that is a principle of international law that must be respected. Once the prosecutor's investigation is complete, it will then be for the court itself to decide whether to issue any warrants against US military personnel. If the ICC prosecutor does make submissions to the court may decide that as the US has a long record of carrying out its own investigations and prosecutions, the court will have to respect the principle of complementarity and leave US authorities to handle any investigations or prosecutions. In that case, the prosecutor of the ICC could, if she wished, turn over any evidence she has to US military authorities, who may decide to investigate the matter further. It does not redound to the credit of US officials when they treat respected international institutions such as the ICC with contempt. Equally, the ICC needs to give careful consideration as to whether there really is a case against US military personnel, and even if it considers that it does, whether the US military is willing and able, based on its past record, to carry out those investigations for itself and to prosecute where necessary. Equally, some may consider it hypocrisy that the US has actively encouraged the ICC to prosecute officials from other countries for war, humanity and genocidal crimes, while refusing to allow its own citizens to be subject of the same procedure. The case of the ICC prosecutor v. Uhuru Kenyatta, the President of the Republic of Kenya, showed that the collection of evidence in crimes against humanity is extraordinarily difficult. Procedures for collecting evidence against President Kenyatta and others indicted by the ICC was badly flawed, which, however, was not the fault of the prosecutor. And although I consider that the court correctly dismissed the case because of the flawed evidence, it is important to respect the prosecutor's right to initiate the investigation, given the number of deaths and other atrocities. What we learn from this case and others like it is that no institution is perfect. We must allow our international institutions time to mature and develop, and they should be given every opportunity and encouragement to do so because of the critical importance in these times of international law. All states, right across the globe, must respect international law and the principles of international law. If the US were to join the ICC, it would bring the benefit of its own outstanding judiciary, its legal scholars and practicing attorneys, to join the other distinguished members of the court. It's very much to be hoped that this will happen in the future. International justice is not possible without international accountability, and without international justice and accountability, we cannot have harmony and comity between nations. And there has never been a time in history when this has been more important. Thank you for listening, and goodbye.